G'day again, and welcome to the second video in week 10 of our admin law course. This week we're looking at access to information and how that ties in with administrative law. In the first video we looked at this conceptually and saw how access to information is important as an accountability mechanism. But we also saw that a number of grounds for review in administrative law are really only effective if you're able to look inside the decision-making process and obtain information about it. In this second video, we start looking at the nuts and bolts of this process. We'll look at information provisions in the ADJR Act, information provisions in specific legislation, and then we'll look at two keynote pieces of legislation, the Freedom of Information Act and the Privacy Act. Finally, we'll talk about two other mechanisms called disclosure logs and Harradine lists, which make the information process actually work. So let's start with the ADJR Act. If your client has received a decision and they disagree with that decision, there's an important step that can be taken immediately before you even identify grounds for review. And that step is to request a statement of reasons. Section 13 of the ADJR Act says that any person who has standing to seek review of a decision can request a statement of reasons in writing, setting out the findings on material questions of fact, referring to evidence or other material on which those findings were based, and giving the reasons for that decision. You can see that with a statement of reasons in hand, you suddenly have a much better basis for analysing the decision and working out whether there's an error of law or whether your client's only real basis for concern is a disagreement on the merits. Section 13 essentially forces the decision maker to clearly state the basis of their decision, which gives you a clear foundation for attacking that decision. In many, many cases, particularly in relation to complex or important decisions, public service departments will now actually automatically provide a statement of reasons, along with the decision itself. This particularly happens when the department knows that it's sending bad news. So this section of the legislation has actually caused cultural change among decision makers. They now understand from the outset that they may be required to present the reasons for their decision. In other cases, the enactment which creates the decision-making power specifically provides for a statement of reasons, which is calibrated, if you like, for that particular decision. Remember our driver logbook example? Let's go back to that legislation. We've been looking at Regulation 32, which is all about approving logbooks. Subregulation 6 says that if the delegate decides not to approve a logbook, they must give the young driver a written statement, including both the reasons for rejecting the logbook and the appeal mechanisms open to the young driver. So, if you're after information specifically about your decision, then the ADJR Act or the specific legislation might offer you some assistance. What if you're looking for broader information though? What if you have an ongoing relationship with a government agency? You might be a person with a disability who has an ongoing relationship with the NDIS agency. You might be a veteran with an ongoing relationship with Veterans Affairs. You might be a seafarer with an ongoing relationship with the Maritime Safety Authority. The list goes on and on. In 1992, the Commonwealth Government passed the Freedom of Information Act. The purpose of the FOI Act is to give people access to government documents. Here's a copy of the Objects Clause of the legislation. There's a similar piece of legislation in Queensland called the Right to Information Act 2009. Its purpose is expressed even more succinctly, to give a right of access to information in the government's possession or under the government's control. Now, you might not realise it, but those objects clauses resulted in an absolute revolution. You see, previously, the working assumption had been that government documents were confidential, perhaps even secret, unless there was a good reason to release them. These acts turned that on its head. Now, The presumption is that all government documents should be made public unless there's a good reason not to. So instead of the information seeker proving why they need to see a document, the government must show that it's exempt from releasing the document. Otherwise, the document must be released. In general, when thinking about FOI, it makes sense to divide claims up into requests for personal information and requests for non-personal information. We're going to talk about personal information first. Personal information is actually defined in the Privacy Act 1998, and it's information or an opinion about an identified individual or an individual who is reasonably identifiable. There's a very strong presumption under both the FOI Act and the Privacy Act that a person must be able to obtain access to their own personal information. The Privacy Act provision is super plain. It says that if a government entity holds personal information about an individual, the entity must, on request by the individual, give the individual access to the information. Put simply, if there's a file on you, then in most cases you can get your hands on that file. However, the value of the FOI processes doesn't stop there. Let's say you or your client do in fact get your hands on the relevant file, and having done so, you see that there's information on that file that isn't quite right. It might be out of date, it might be out of context, it might be incomplete in important ways, and it might just be plain wrong. Well, the FOI process gives you an opportunity to apply to amend or annotate those records. If you think about it, all of this fits fairly neatly with the grounds for review. Let's say your client gets an adverse administrative decision. As a first step, they apply for a statement of reasons, and they see that the decision was made based on information which is out of date. Then they apply to have the record amended, and at the same time, they apply for reconsideration of the decision on the basis of a failure to take into account relevant information. When you use the tools of administrative law together with the rules of freedom of information, you've got a powerful tool to use on behalf of your client. Now, I want to move on to non-personal information. In most cases, freedom of information requests for non-personal information are more likely to be the focus of people like journalists or the political opposition. But I'm sure you can see that sometimes, in order to assist your client to challenge a decision, it might be helpful to obtain departmental documents about processes and policies that might not specifically pertain to your client. The FOI process does allow you to obtain access to non-personal information in departmental files, unless that information is protected by one of the exemptions that we're going to look at in the third video. This fact has given rise to two little known but super useful administrative processes. The first is what we call a Harradine list. This is the late Brian Harradine. He was a senator for Tasmania who sat for many years as an independent, but in truth, he was really a conservative Labor man, which is not the contradiction you might think. I didn't always agree with his politics, but when I was working in the Senate, he was an absolute gentleman who had the respect of both sides of the chamber. Senator Harradine realised that FOI was really limited by the fact that applications were required to specify the documents you wanted to see. This meant that it was hard to make applications if you didn't already know what information the government was holding and which government agencies had the information. Can you see the conundrum? You couldn't make the application if you didn't know what was there, and you wouldn't know what was there until you made the application. Senator Harradine pushed through a new rule that once every 6 months, every Commonwealth government department and agency must publish an index of all their non-exempt files. This means that people who are making FOI requests for non-personal information can actually know what to apply for. Mind-bogglingly useful. Second, and perhaps even more useful, every department is now required to publish what are called disclosure logs. In short, every time someone makes a successful request for non-personal information, the information is not just released to them, it's released to everyone. The department has to identify on its website the fact that it's released that information, which means effectively anyone else who wants that information is going to be able to get it because it's already clear that this information is subject to FOI. So now we know a bit about obtaining information from the government. The ADJR Act and many individual acts require the department to provide a statement of reasons for their decision. The FOI Act and the Privacy Act together provide individuals with the right to obtain their personal information. And the FOI Act, together with the Harradine lists and the disclosure logs, provide opportunities for interested parties to obtain non-personal information from the government. The devil, however, is in the detail. Many types of documents are exempt from release. In the next video, we'll round out our understanding of FOI by looking at those exemptions.